In the previous videos, I have started a series of Canadian constitutional law. First part is sources of Canadian constitutional law. I have already uploaded the video. The first part of the amendment have also been recorded and uploaded the video on my channel. I request all of you, if you have already watched those videos, very good. If you have not watched those videos, please do watch those two videos under the playlist Canadian Constitutional Law NCA. Today we have to discuss the second part of Canadian Constitutional Law amendments. Before discussing this amendment to the Canadian Constitutional Law, we must know how the Canadian Constitutional Law developed in Canada. I have already discussed a lot about it. Still, for your information and convenience, I am again repeating some part of it. As you are well aware that Canada was a British colony, and in the year 1867 the British Parliament, which is also known as Westminster Parliament, had passed a BNA Act 1867, that is British North America Act 1867. This is the first step towards constitutional history of Canada. Now this act established a federal structure, strictly not federal, but still we can say a federal structure in Canada, that is a Dominion and the regional bodies. Dominion means a federal parliament and regional bodies means provincial legislative assemblies. Initially some of the provinces agreed and joined the Dominion, and subsequently with the passage of time the other provinces also joined the Dominion. And there are 10 provinces, you are well aware, 10 provinces, 3 territories in the Canadian legal system, jurisdictional system. Now with the advent of 1867 Act, the federal structure was established, the distribution of powers were established. There was a provision for the establishment of judicial system, but strictly no court was under that act established. However, lately the Supreme Court Act was passed by the federal parliament and the Supreme Court of Canada was established. This process continued with two major flaws in the 1867 Act. One, the fundamental rights, or in other words we can say charter rights, were not made a part of 1867 Act. Second, there was no provision under the 1867 Act regarding the amendment of that Act. So meaning thereby the parent body, that is the UK Parliament, is the only authority which is competent to amend the BNA Act 1867. There was a consistent and constant development and demand regarding, one segment says the amendment of the BNA Act, the power to amend the BNA Act has to be given to the federal parliament or the provincial legislatures, as the case may be. The other majority of the segment was of the view that it should remain with the UK Parliament. The convention was established finally in the year 1895, and that convention is that BNA Act was not to be amended except on the agreed terms, and the convention is that there should be a request by the Federal Parliament of Canada for the amendment of BNA Act 1867, and that request should be supported by a resolution of the Parliament, and then after the resolution is passed, it should be sent to the UK government, and the UK government should be given the request that we want this amendment in the BNA Act 1867 supported by a resolution of the Federal Parliament, and finally UK government may lay before the UK Parliament for such an enactment, and finally if the UK Parliament passed that legislation, it was considered to be a amendment or an amendment under the BNA Act 1867. Then again in 1930 a Westminster conference was held. These issues were again considered, and finally in 1931 Westminster Statute was passed. Still this power of amendment of BNA Act 1867 remained with the UK Parliament. All other ordinary legislations, the Federal Parliament or the Provincial Legislative Assemblies, as the case may be, as per the distribution of power and their legislative competency, they are competent to repeal a law, ordinary law, or may amend the law, whatever they want. But regarding BNA Act 1867, still the amending power vested with the UK Parliament. So the old convention of 1895 continued. There were demands that this amending power should be now given to the Federal Parliament of Canada. Finally, the then Prime Minister Trudeau Sr. made the efforts, and ultimately the Canada Act 1982 was passed, where the then Prime Minister prevailed upon 9 provinces, and the one province which was not agreeable, rather we can say not agreed with the Canada Act 1982 is Quebec. Finally again the old conventional process was adopted while getting the legislation of Canada Act 1982. It is a small act containing 4 sections. The request was made by the Federal Parliament, supported by a resolution and consent of 9 provinces, that we want this constitution, this Canada Act, has a Schedule B in the shape of Constitution Act 1982. Finally, the Canada Act was passed by the UK Parliament along with the schedule. The impact of 1982 Act was: 1. The Canada Act is the parent act in the history of Constitution of Canada. Now it contains Constitution Act 1982 as Schedule B. The effect came as a impact on the constitutional system of Canada is that Constitution Act 1982 is a complete code or not? It is not. Again, the conglomeration of all the different statutes. 1. The BNA Act 1867 was renamed as Constitution Act 1867. It was not repealed. It still remained in force. Second, in the Constitution Act 1982, the amending process has been adopted. Part 5 of the Act is devoted to different processes of amendment of the Constitution of Canada. And the third and the most important is the Charter of Rights. A complete chapter has been devoted to Charter of Rights, and the Charter of Rights, or we can say the fundamental rights or the basic rights of human being, have been given the status of constitutional right under the Constitution Act 1982. So now today we are only concentrating on the amending process of the Constitution of Canada. There are 2 types of amending processes under Part 5. One is a general and another is a specific. I'll just take you to this part. One is general amending process of the Constitution of Canada. It is contained in section 38 of the Act 1982. Other is specific amending process or procedure of the amendment of the Constitution of Canada, that is contained in section 41, 43, 44 and 45. 41 is unanimity procedure. 43 is some but not all provinces procedure. Then the other the specific process of amendment is only the federal parliament can amend the specific provisions of the Constitution. And the last is section 45, that each province has the power to amend a particular part of the Constitution of Canada. So individually, federal parliament has given exclusive power on the amendment qua certain provisions. Provincial legislature has also given the exclusive power to amend the Constitution, and some part of it of the Constitution where federal parliament has to pass the resolutions, but some of the provinces has to pass the resolution in favor of the amendment, where those constitutional provisions which are likely to be amended pertains to those specific provinces. And the unanimity procedure is that the federal parliament as well as all the legislative assemblies of all the provinces has to give the consent. Now come to this part. This is general. It is called general procedure of amendment. It is called residual power of amendment. It is contained under section 38. Now section 38 is where section 41, 43, 44, 45 procedures are not applicable. Then section 38 is applicable. This is also known as 750 formula. We'll explain it. I'll explain it further why it is called 750 formula. And under section 38, one is the general amending power, where no procedure of amendment is prescribed under section 41, 43, 44 and 45. Section 38 is applicable. And the second part is 6 types of constitutional provisions have been mentioned under section 42. So if those 6 instances or the provisions of the Constitution are to be amended, then the procedure under section 38 is applicable. I'll just again explain it. If one is specific provisions of the Constitution can be amended by way of these specific provisions, 41, 43, 44 and 45. Specific provisions of the Constitution has been mentioned, and specific procedure of amendment for those provisions have been mentioned in these sections. If there is no procedure prescribed for the amendment of the remaining part of the Constitution, section 38 is applicable. So this is a general amending procedure. And 42, section 42 clearly states that these 6 types of constitutional provisions, the procedure under section 38 of the Constitution for amendment of those provisions is applicable. Now I'll just read section 38 for your convenience at the first stage. It says, an amendment to the Constitution of Canada, you just pick up the Constitution of Canada, that is Constitution Act 1982, and may read along with me section 38. I'll just read for your convenience so that you can have a better understanding. An amendment to the Constitution of Canada may be made by proclamation issued by the Governor General under the Great Seal of Canada, where so authorized. So, Governor General may issue a proclamation under the Great Seal of Canada if that is supported by a resolution. What type of resolution? It says A a resolution by the Senate and the House of Commons, meaning thereby a resolution in support of that amendment has to be passed by the Senate and the House of Commons. And further it says, and B, resolution of the legislative assemblies of at least 2/3 of the provinces that have in the aggregate, according to the then latest general census, at least 50% of the population of all the provinces. Now, the proclamation for declaring a particular amendment by the Governor General under the Great Seal of Canada can be issued only if the resolution is to be passed. Resolution has been passed by the Senate and the House of Commons. Very simple. Now the second part is very important, that 2/3 of the provinces has passed the resolution in support of that amendment. One. Second, now those 2/3 provinces in aggregate have 50% of the total population, and the population is to be counted from when? The last census. And the aggregate of the population of all the 2/3 provinces who has passed the resolution in favor of the amendment as per the last census must be 50%. It says in aggregate, according to the latest census, at least 50%. At least, minimum is 50%. It may be 50, 51, 52, 53, 60, whatever it may be. But at least 50, minimum 50% requirement is there. I'll just further explain it to you for your convenience. It says, 1, proclamation. Second, that should be issued by the Governor General. Third is under the Great Seal of Canada. Right? Now this resolution, this proclamation has to be supported by the resolutions. Now, first resolution is by the House of Commons and Senate. Very clear. So a resolution in support of that amendment has to be passed by the House of Commons and Senate. Second is a resolution in support of this amendment has to be passed by 2/3 of the provinces. This is the first condition. Second condition is at least 50% population of these 2/3 provinces, at least as per the last census, and this is in aggregate of total provinces. Just try to understand. I'll explain it further. There are 10 provinces. 2/3 is 7. Now Ontario and Quebec, these are the two majorly populated provinces of Canada. If both of these two provinces not pass the resolution, then indirectly we can say that resolution of amendment fails, because if both the provinces have more than 50% of the population of Canada, so meaning thereby indirectly we can understand that either of these two provinces has to give the consent and pass the resolution in support of that amendment. There is one part. Second is out of these 7, so one is Ontario or Quebec, they have to give the consent. Suppose Ontario has given the consent. Now the remaining 6, 1 plus 6, these two things, that is 1 Ontario province and 6 other provinces have passed the resolution in favor of the amendment, and their total aggregate of population should be at least 50% of the total population of Canada as per the last census. I think now you have followed it. So if an amendment has to be carried out as per the procedure prescribed under section 38, then it has to be supported by the resolutions of the federal parliament and the 2/3 legislative assemblies of the provinces as per the requirement of populace. Now there is another example we can discuss about it. It says the initiation and proclamation. Now initiation may be at the federal parliament or with the provincial legislative assembly. Now there is another aspect that is provided under section 38(3), subsection 3, which is also very important. It is section 38(3), opting out. There are two aspects, one is assent, another is the dissent. Now before discussing this part, there is another part of this also, that is the time period. Let us discuss first time limit. It says, from the initiation of the resolution for amendment, the proclamation has to be issued within 1 year. Within 1 year. But it shall not exceed the period of 3 years. So any resolution when initiated for the amendment under section 38 has to be issued after the lapse of 1 year, but it shall not be issued by the Governor General as a proclamation for amendment after 3 years of the initiation of the resolution. So this is the time limit. 1 year is the minimum which has to be complied with, and 3 years is the maximum. Within this period, this proclamation has to be issued. Now coming to the other part, this assent and dissent. We can say opting out. Now once a resolution is initiated for the amendment under section 38, the provincial legislative assemblies have two options. One is very simple, they can give their assent by passing a resolution in favor of the amendment. It's very simple. Second is they may give the dissent by passing a resolution by the legislative assembly that they are not willing to accept this resolution they are not willing to accept this amendment, and they are opting out of this amendment. This is called dissenting resolution. Very clear? Within 1 year or till the proclamation is issued, they have the power to give their assent, they have the power to give their dissent by passing a resolution. And the third and the most important part is they may keep silent also. They have not passed any assent, giving their assent to a resolution in favor of the amendment. They have not passed any dissent resolution that they are not agreeing with the proposed amendment. So they have neither passed the assent resolution nor passed the dissent resolution. It is again with their discretion. But the requirement is 7 provinces, that is 2/3, has to give. Now take an example, just to understand further. 10 provinces, out of this 7 provinces passed a assent resolution. One province, that is Quebec, has passed a dissent resolution, right? And the other 2 provinces, say New Brunswick and Newfoundland, they have not passed any resolution. They have neither passed the assent resolution nor passed the dissent resolution. They can do it. They have the prerogative. So they keep mum qua the proposed amendment. Finally, the resolution fulfills the requirement as laid down under section 38. The resolution has been passed by the federal parliament, that is the House of Commons and Senate. 2/3 of the provinces, that is 7 provinces, have passed the resolution in favor of the amendment, and they constitute at least 50% of the population in aggregate as per the last census. So meaning thereby the requirement of section 38 are fulfilled. Here dissent has been given by 1 province. 2 provinces has not passed any resolution either of dissent or assent. The amendment can be carried forward. The proclamation can be issued after 1 year, but before the lapse of 3 years from the initiation of the resolution of amendment. Now, question is whether this province of Quebec can withdraw its dissent. Suppose the amendment has been carried out, proclamation has been issued, and subsequently this province realize that it is not in the interest of the people of Quebec, so they have decided that they want this amendment to be applicable in their province. Can they withdraw the dissent? The answer is yes. They can withdraw their resolution of dissent at any point of time, even after the proclamation of Governor General under the Great Seal of Canada has been issued. At any point of time. Suppose the proclamation has been issued in the year 2015. They can withdraw their dissent in the year 2020, and that amendment is applicable in the province of Quebec after the withdrawal of their dissent. Now the other question is, now these 2 provinces have neither passed any resolution of assent or dissent. What is the impact? This amendment which has been carried out is not applicable in the state of province of Quebec because they have passed the resolution of dissent. But these 2 provinces have not passed any resolution of assent or dissent. The amendment is applicable in these 2 provinces. Make it very clear. The provinces which have neither passed any assent or dissent resolution qua that proposed amendment under section 38, then once the proclamation has been issued by the Governor General under the Great Seal of Canada under Section 38, carrying out that amendment is applicable as if it has been applicable in the cases of the 7 provinces who have given the assent. So it is applicable. Now the question is, what is the impact of opting out? Before that, one more question. Suppose Ontario has given the assent. Ontario Legislative Assembly has passed a resolution giving their assent to the proposed amendment. Can they withdraw their assent? The answer is twofold. One, yes, before the proclamation is issued, they can withdraw their assent. But once the proclamation is issued by the Governor General, they cannot withdraw by any means their assent. Like dissent, they can withdraw even after the proclamation, but the provinces which have given the assent, they cannot withdraw their assent once the proclamation is issued. Before the issuance of the proclamation, they can withdraw it. Why? This is the reason that ultimately, if on the basis of the strength of the assent of 2/3 provinces, a proclamation has been issued, an amendment has been carried out in the Constitution. If this right of withdrawal of assent is given to any of the provinces or all of the provinces, then it may destroy the whole process at any stage. So an embargo has been created that assenting state cannot withdraw its assent to the amendment after the proclamation is issued. Yes, before the issuance of the proclamation. That's why 1 year period has been given to rethink. Now, what is the impact of opting out? What is the impact of opting out? As we have discussed, the province of Quebec has opted out of the amendment by passing a dissent resolution, and 2 other provinces have not passed any of the resolution, either assent or dissent. What is the impact of opting out? Effect of opting out is that the amendment which has been made to the Constitution is not applicable in that province. This is one. Now the second and the most important part is, if that amendment is pertaining to educational or other cultural matters. It is education or other cultural matters. If this amendment is being carried out, then the Government of Canada, not the legislature, Government of Canada is under a constitutional obligation to compensate that province which has opted out of the amendment. Suppose the universities and the legislative power qua the universities has been taken over by the federal parliament through this amendment, through a particular amendment, and this province of Quebec has opted out by passing a dissent resolution. Now other 9 provinces are being benefited by the financial assistance being given to the universities. Then this province of Quebec, which has opted out, is at a disadvantageous position. Then the Constitution, Section 40, has protected such a province that if the amendment is for education or cultural matters, and the province which has opted out is to be compensated by Canada. Canada means the Government of Canada. But in regard to any other amendment, of the provisions of the Constitution, this section 40 is not applicable, and the dissenting state, the opting out, will not come forward and help that province for claiming compensation as a constitutional right. Section 40 is a part of the Constitution, and the province which has opted out has a constitutional right to claim the compensation if such an amendment is in regard to education or cultural rights or matters. But any other amendment of the Constitution of Canada which has been carried out under section 38, then the province which has opted out cannot claim the compensation as a constitutional right under section 40 of the Constitution Act 1982. Right? So this is the impact of opting out and the right of compensation under section 40 if the amendment is in regard to education or cultural matters. Then we have to discuss the important part. Now, I have started with this part that under the amendment procedure under section 38 is a general amending procedure, meaning thereby where 41, 43, 44, 45 are not applicable, then this general amending procedure is applicable. Along with that, there are 6 parts, 6 matters which have been prescribed under section 42 of the Constitution Act 1982, where the procedure for amendment under section 38 is applicable. I'll just again read for your convenience, and then we will discuss that what are those matters contained under section 42. Section 42 says, subsection 1, an amendment to the Constitution of Canada, please pick up the Constitution Act 1982, take section 42, subsection 1, I am reading for your convenience. An amendment to the Constitution of Canada in relation to the following matters may be made only in accordance with subsection 38, subsection 1. A. The principle of proportionate representation of the provinces in the House of Commons prescribed by the Constitution of Canada. B. The powers of Senate and the method of selecting senators. C. The number of members by which a province is entitled to be represented in the Senate and the residence qualification of senators. D. Subject to paragraph 41D, the Supreme Court of Canada. And E is the extension of existing provinces into the territories. And the last one, F, is notwithstanding any other law or practice, the establishment of new provinces. Now let us, first part, first is the principle of proportionate representation of the provinces in the House of Commons prescribed by the Constitution of Canada. As you are well aware, House of Commons, there is a representation by all the provinces. It is based on proportionate representation, and if any amendment is to be carried out which is going to disturb this proportionate representation of the provinces in the House of Commons, then the procedure prescribed under section 38(1) for amendment of the Constitution is to be followed. Now, second is powers of the Senate and the method of selecting senator. Now, power of the Senate. Whatever the powers of the Senate under the Constitution, if they want to change it, may want to enhance it, may want to scuttle down it. And second is method of selecting. Method of selecting the senators. So if any amendment is to be carried out regarding the powers of the Senate, which is affecting the power of the Senate, or their method of selection of the senators, suppose a certain powers are vested with the Senate, and now through the amendment they want to scuttle down certain powers, they want to take away those powers from the Senate, then the process under section 38(1) of the Constitution Act 1982 has to be followed for carrying out that amendment. Second is, if the method of selection of the senators is to be disturbed, it's to be changed, is to be altered, it is to be affecting either in favor of the provinces or against the provinces, whatever it may be. If they want to change that method of selection of the senators, then the process or the procedure for amendment of the Constitution as prescribed under section 38(1) is to be applicable. Now the third is the number of members by which a province is entitled to be represented in the Senate. Number of members to be represented in the Senate of a province. As you are well aware, each province has the representation in the Senate through their senators, and if this number is to be altered, increased or decreased, this process under section 38(1) has to be followed for amendment of the Constitution. Second part is residence qualification of senators. There is another qualification prescribed regarding residence. Residence qualification is prescribed to become a senator. I am just taking a hypothetical situation that a person who is a resident of a province, say Newfoundland, cannot be elected as a senator from the province of Ontario. So residence qualification is there. If they want to alter it by saying that any person who is a citizen of Canada may enter into a senator as a senator from any of the province. Suppose he is a resident of Ontario, he may be selected as a senator from Newfoundland. It means they are changing the residence qualification. If such an amendment is to be carried out, then again the procedure prescribed under section 38(1) of the Constitution is to be followed. Then fourth is subject to paragraph 41D, the Supreme Court of Canada. Supreme Court of Canada. A very interesting thing. Like in India, the Supreme Court of India has been established by the Constitution, or we can say it is an organ, it is an institution established by the Constitution of India. But in Canada, Supreme Court of Canada is not established either under the Constitution Act 1867 or Canada Act 1982 or Constitution Act 1982. So it is not till date treated as a constitutional body. Once it is not, there is no provision under the Constitution, then we can say this provision under section 42 is meaningless. Then the next is extension of existing provinces into the territories. So existing provinces may be converted into, may be treated as, may be extended into territories. If such an amendment is to be carried out, then procedure under section 38(1) is to be followed. And the last is, it says, notwithstanding any other law or practice, the establishment of new provinces. So, irrespective of any other law, if new provinces are to be established, then the amendment procedure is, because it is an amendment, if you want to create new province or provinces, there is an amendment to the provisions of the Constitution. So, the procedure prescribed under section 38(1) of the Constitution, Act 1982, has to be followed. And the most important, 42, section 42, subsection 2. What it says? It says subsection 38(2) to subsection 38(4) do not apply in respect of amendments in relation to matters referred to in subsection 1. So meaning thereby, any amendment or amendments being carried out in the light of section 42, then that provision of assent, dissent, opting out is not applicable. The provision of compensation is not applicable. So section 38(1), only the procedure has been taken away, taken for amendment. I'll just explain it in the other words. If any of the provisions of the Constitution are to be amended as per section 42, then only the procedure prescribed under section 38(1) is to be followed. Rest of the provision is not applicable if that amendment is pertaining to the matters which are prescribed under section 42. So this is all about section 42. Now the next procedure is unanimity procedure, that is section 41. It is unanimity procedure. Unanimity procedure, section 41. Again, I'll read for your convenience. Please take the Constitution Act 1982. I'll read for your convenience section 41, and then we will discuss. Section 41 says, an amendment to the Constitution of Canada in relation to the following matters may be made by proclamation issued by the Governor General under the Great Seal of Canada, only where authorized by resolutions of the Senate and the House of Commons and of the Legislative Assembly of each province. First, we will discuss this part only, 41, that the proclamation has to be issued by the Governor General under the Great Seal of Canada only when it is supported by the resolution passed by the House of Commons, Senate, and all the provinces. Here, exception is not there that 2/3 or population, whatever. It clearly, in unequivocal terms, clearly states that that resolution has to be passed by the House of Commons, that resolution has to be passed by the Senate, and that resolution has to be passed by all the provinces. Now the next part of this is that where this procedure of amendment, what are those provisions of the Constitution which are to be amended only by way of unanimity procedure. I'll read for that. The office of the Queen, the Governor General, and the Lieutenant Governor of a province. If there is any amendment pertaining to the office of the Queen, Governor General, or the Lieutenant Governor, then this unanimity procedure has to be followed. B is right of a province to a number of members in the House of Commons not less than the number of senators by which the province is entitled to be represented at the time this part comes into force. Again, you are well aware that the House of Commons has the representatives of each province. The number is fixed at the time when this Constitution Act 1982 came into force. It says whatever be the representation of each province in the House of Commons, that cannot be less than whatever it was at the time when this Part 5 of the Constitution Act 1982 came into force. When this Act 1982 came into force, Part 5 also came into force, and at that point of time, whatever be the representation of each province in the House of Commons, that cannot be altered. If they want to alter it, then they have to follow the unanimity procedure. Then the next is subject to section 43, the use of English or the French language. Now, subject to section 43, we will discuss later on, the use of English or French language in the nation. Then this unanimity procedure has to be followed. Next is composition of the Supreme Court of India. Again, the composition can be altered by way of ordinary legislation, because the Supreme Court of Canada has been established by way of an ordinary legislation, and that can be amended by way of an ordinary legislation. However, this provision has been incorporated for the reasons best known to those constitutional makers. The next is an amendment of this part. Very important. If this Part 5 of the Constitution Act 1982 is to be amended, the procedure of amendments, as we are discussing, all these provisions contained in Part 5 of the Constitution. If any of the provision or all of the provision, whatever it may be, is to be amended, is proposed to be amended, then the procedure for amendment of the Constitution as prescribed under section 41, that is unanimity procedure, has to be followed if they want to amend any of the part or whole of the part of Part 5 of the Constitution. So this is all about section 41. Then there is a section 43, some but not all provinces procedure. Section 43 says an amendment to the Constitution of Canada in reference to any province that applies to one or more but not all provinces. Very simple. The title of this provision suggests us that it is the proposed amendment is not applicable in regard to all the provinces, but it applies to some of the provinces. The title is Some but Not All Provinces Procedure. Then what are those provisions? One is any alteration to boundaries between provinces. If two provinces are involved, suppose there is a dispute between two provinces, say Quebec and Ontario, they have the dispute. Other provinces are not interested, other provinces are not affected, other provinces' interest is not at all impacted by such an amendment, then this procedure of amendment can be followed. Second is any amendment to any of the provisions that relates to the use of English or the French language within a province. Suppose any of the amendment, like take an example in Quebec, there is a first language in the shape of French. They want to make an amendment within the province of Quebec. Then all other 9 provinces are not related. So if any amendment is to be carried out regarding that language within that province, then this procedure prescribed under section 43 is applicable. Take an example in the Ontario and British Columbia, they have decided that let the Punjabi be declared as a second language. Whether that is applicable? The answer is no. Why? Because it says, the provision says, any amendment to any provision that relates to the use of English or the French language within that province. So this is not applicable. Then it says, may be made by proclamation issued by the Governor General under the Great Seal of Canada only where so authorized by resolutions of the Senate and the House of Commons and of the Legislative Assembly of each province to which the amendment applies. So wherever the amendment applies, the resolution has to be passed by that concerned Legislative Assembly of the province along with the resolution of the House of Commons and the Senate. Only then the proclamation can be issued by the Governor General under the Great Seal of Canada. So this is the procedure for amendment where some of the provinces are affected but not all the provinces. Then the next is section 44. It is federal parliament alone. Very important. Section 44, federal parliament alone is competent to carry on the amendment to the Constitution. No province is involved, no province is required to pass a resolution in support of such an amendment. But what is the scope? Section 44, I am reading for your better understanding. It says, subject to section 41 and 42, Parliament may exclusively make laws amending the Constitution of Canada in relation to the executive government of Canada or the Senate and House of Commons. So any power, executive power of Canada or any power relating to Senate or House of Commons, the federal parliament may pass a resolution for the amendment of the constitutional provisions like an ordinary legislation. But it is, the opening words are subject to section 41 and 42. If any of the provisions of the Constitution are covered under section 41 or covered under section 42, then the federal parliament has not the exclusive power to amend. Then the procedure prescribed under section 41 or 38(1) are to be applied. So meaning thereby, if the proposed amendment is not covered under section 41 or 42, then any matter relating to the executive power of Government of Canada or the Senate and the House of Commons, then the federal parliament alone has the power to amend the Constitution. And the last is relating to section 45. Here the provincial legislative assembly alone has the power to amend the Constitution. Which Constitution? Very important. Whole of the Constitution or not? I'll just read section 45. It says subject to section 41. So first exception carved out, restriction carved out is it is subject to section 41. Second, the legislature of each province may exclusively make laws amending the constitution of the province. Very important. Very important. It says the legislature of each province may exclusively make laws amending the constitution of the province, not the constitution as a whole. It is very important. Constitution of the province. So two riders are there. One is it is subject to section 41. Second is it is only pertaining to the constitution of the province. There are specific provisions under the 1867 Act which have not been repealed and still governing, pertaining to the provinces, their constitutions. So if those provisions are still applicable and the province which has, like Manitoba, Quebec, they have their separate acts and those are part of approved by, we can say, under the 1867 Act and the subsequent Constitution Act 1982, Canada Act 1982 have not repealed, then that particular province may make an amendment exclusively by passing a resolution of its own legislative assembly, but that should not also covered under section 41. So this is regarding the chapter of amendment. In the next video we will discuss the issue regarding the chapter regarding distribution of power and judicial review. Thank you very much. God bless you.